Hello, welcome to CLC News. Today is the 28th of February 2020. Welcome to all our viewers. Today we'll be covering three issues. First of all, we'd like to highlight the fact that we have another couple of countries signed up to the Common Law Court. This confirms that individuals from the various countries have submitted a declaration for their birth, and the current number we have just now is 91 separate countries. If you wish to have a look at the full list of the countries, you can do so by visiting the website. Go to the community heading and scroll down to the category called documentation, and within that you'll see that the final category is called website. If you click onto there will be the option to view the list of countries. There's also a map of the world to confirm basically how far this concept spread. We'd also like to thank the latest viewers to come on from the additional countries, because we have been speaking to two or three parties over the last few weeks, and we'd like to highlight that in addition to the existing courts that are up and running within Australia and probably New Zealand in the very near future, we'll be setting up some courts there. In addition to this, what we're hoping to do on the website in the coming weeks is set up an international page for the various countries that are actually using this regularly. The aim of setting up this, or the purpose of setting it up, is to allow these individuals to highlight relevant issues for the appropriate country. What we'd also like to do just now is give you a slight update in relation to the position with the up and coming countries. Now, there are many countries looking to use this concept. We've highlighted that we have Australia and possibly New Zealand will commence their own courts soon. What we'd like to do is highlight that there are many other countries who are using this on a regular basis, and there seems to be quite an influx of people from just now France and even Spain join up. The French in particular seem to be wanting to use this to address some of the problems that they're having over there. So I welcome everyone in France if they are watching this, and we'd love to try and help and assist in the coming weeks. The next issue we'd like to address is that of the void orders. In the past few weeks we have been voiding various orders from within the statutory system. Now, if you've been watching the latest news programmes over the coming weeks, you will be aware of what's going on. However, for those who are not aware, simply put, their existing system, meaning the statutory system, have or offer a facility whereby if they have created an order or established an order within their so-called courts, by using a fundamental flaw, the order itself can be voided, which we've done. Now, there is information on the site about this, but numerous people have been submitting these void orders into the courts. Now, each and every one of these orders still remains a void order, so therefore the original orders have no weight at all. However, this is what we require from the existing authorities, is that these orders are put aside, are set aside. Unfortunately, the judges, although accepting the void orders that they have them in their possession, they don't wish to set them aside, which they can be held personally liable for. They can also be held liable for damages and prosecuted for failing to comply with their own legislation. Now, while we have an option to address this with the individual judges, it was felt that the best way to address this to benefit everyone is by going to the Attorney General. So the Attorney General is receiving letters as we speak this week, and will continue on a daily basis to have these orders set aside. Now, she's been given 7 days to make sure that these orders are set aside, after which she will then be personally liable for damages. In relation to the issue of the void orders, we're going to obviously clarify a few points again, and we're going to ask you once again to think about what the courts, or their so-called courts, are doing. Effectively, remember that these places and their so-called courts are only places of business, and in fact that these courts and the judicial system are all corporations run for profit. So they don't exist for justice, they're there for profit. Now, when we go before so-called magistrates or judges within these courts, there is a fundamental issue because, well, there's many, but one of the main issues we have is that these judges, magistrates, are believing that they have the authority to adjudicate in matters before you, even against a living man or a living woman. When there's no contract, there's no consent, they have no jurisdiction, and they cannot proceed. However, in doing so, they're also committing various crimes. So we've actually had a look at the situation to examine it and have a think about it. If we look at the courts, when you go into these so-called courts, you will go before a magistrate or a judge who is there to adjudicate, nothing more. Now, they have to deal with this issue, but remember, they require obviously a contract, jurisdiction, authority to do so, which they don't have. Now, the problem is, excuse me, the problem is when you actually identify yourself as a living man or a living woman, the judges don't want to know about it. So when we look at this situation just now, we examine what we're doing, we have the option whereby you can have a living man or a living woman in court, in their court. You also have the option whereby they could be addressing a legal fiction. Now, a legal fiction is actually a dead entity. It doesn't exist. It doesn't have life. And again, it's just a fiction. But these are the only things that the existing judges in courts can deal with. They have no authority over a living man or a living woman. So when you go into court and you identify yourself as a living man or woman, first of all, there's a few things happen. The judge doesn't seem to have the mental ability to determine whether or not you're a living man or a living woman. Now, if that's the case, it could be put that this judge or magistrate is not fit to sit in the bench to adjudicate in any matters, because if they are lacking mentally or they're not stable, if they cannot determine the fact that they have a living man or woman in front of them, they shouldn't be sitting there. In fact, to be quite honest, they should be questioned. Now, if you look at the next one, if they're not dealing with a living man or woman, yet they're speaking to them, and they still can't determine whether they're alive or dead, that causes concern. But what they will readily do is communicate with dead people, dead fictions. If you identify yourself as a dead fiction, as in the legal title and the legal entity, in doing so, the judges are happy to speak to you. Now, this, by the letter of their rules, laws if you want to call it, they're not laws, but basically if you want to look at the structure that they use, effectively what we have is we have a judge or a magistrate who openly admits talking to dead people. Now, I don't know about yourself, but if I was to start going about outside and telling people that I can talk to dead people, I would presume that it'd be sectioned or it'd be locked away somewhere, secure. Now, these judges every day within their places of business are confirming that they speak to dead people. So there's something wrong there somewhere. There's also something wrong when they can't determine that in fact they're actually speaking to a live, living individual, a man or a woman. So therefore it can be questioned, that their mental stability is in question, and they shouldn't actually be sitting there in determination of any issue before them, because obviously there's doubt about their mental ability when they start speaking to dead people. There is a question that if that's the case, they should be either seeing a doctor, and there's a possibility they should be on medication to protect not only themselves but the public. So it's an interesting thought. The one other issue I'd like to point out, is just personally, from my point of view, I don't believe that these judges and magistrates are mentally unstable. It could be argued that they are, but it says, okay, we'll give them a benefit of the doubt, and I'd like to think that they're not. Now, if they're not, that now creates another problem, because if they're not, effectively what they're doing is they acknowledge or they know that before them they have a living man or woman. But if that's the case, They're then ignoring this completely, and they're committing crimes through personation, battery, criminal coercion. They're even breaching their own legislation in relation to the United Nations Declaration of Human Rights and also the 2015 Slavery Act, which obviously confirms that we're all bound into slavery. Now, when the letters are going into the Attorney General, the Attorney General literally has two choices. She can either confirm that the judges are mentally unstable and that they need looked at because, first of all, they speak to dead people and they cannot see living people in front of them, men and women, and they can't acknowledge the fact that they are living. If that's not the case and they are mentally stable, well, the next question you have is that each and every one of these judges are committing crimes against the people through obviously the crimes mentioned beforehand. So therefore, the Attorney General is going to be in a very difficult position to deal with this. However, under their own legislation and rules, she can be held personally liable for damages if these orders are not set aside. So the paperwork has went down. We'll wait to see if any what response we get, and we'll inform the public. There are many people putting in these papers just now in the letters. Now, if you have an existing void order and you have used this process, there is a template letter available on the website. If you go to the community heading, underneath that, go to the selection for documentation. In documentation, the third option available is one called court. If you click onto that, there is a template letter available which basically says letter to Attorney General. All you're required to do is to put in your personal information, i.e. the text that's highlighted in red, amend the text, put in your personal details, and then when you've completed that, make sure that all the text is changed colour back to black, sign the paperwork, and then what we'd like you to do is take this letter, attach a copy of your void order with all the exhibits, add this letter onto the front, and then send it off to the Attorney General at the address on the letterhead. Send it in by recorded delivery and then wait to see the response. Okay. If we get any response at all, we will let everyone know what's going on, but if you wish to download this letter, it's a Word document, you can download it on the site, so it's available now. On a final point, what we'd like to do just now is explain that there are many court cases coming up just now. There's one or two in particular that are actually really good. We have one which I believe is on the 6th of April. It's coming up. It is a jury trial. It's a case against an individual who has been removed from his property 4 times. He's been assaulted by the police and the bailiffs. We have proof of that, photographic proof and evidence. But this individual, who's a double transplant patient, and as a result, he's actually been targeted by the CPS, who have stated that he assaulted the police. So we actually have a jury trial available in Portsmouth on the 6th of April. We'll confirm these details a little bit near the time, but what we're hoping to do is have a large turnout to this case. Thank you for joining. Again, keep an eye on this site. We'll try and get another video up within the next week anyway, just with up-to-date news. And for everyone that's joining from abroad, please share this information to your friends, family members. So welcome, and look forward to working with you in the future. Bye for now.